many thanks for coming to this Diversity Festival event. My name's Catherine Fagan. I'm HR Manager for Diversity and I organise the Diversity Festival. And I'd just like to thank Paul Taylor for allowing the Diversity Festival to hijack one of the criminology lectures with one of our Diversity Festival guest speakers. So I know we've got a mix in the room today of criminology students as well as external visitors and staff from other departments and students from other courses as well. So the title of today's event is No One Knows Offenders with Learning Disabilities and Difficulties. No One Knows is a UK-wide programme of work to investigate and improve the treatment of people with learning disabilities and difficulties in the criminal justice system. I'm very pleased to welcome Jenny Talbot, who's Programme Manager for this initiative at the Prison Reform Trust. Jenny's worked at the Prison Reform Trust since 2006, focusing on offenders with learning disabilities and difficulties. More recently, the focus has shifted from adults to children and young people in the criminal justice system. And so she's going to talk about the challenges faced by children and adults with learning disabilities who enter the criminal justice system. So we're just going to start with a DVD that's just 2 or 3 minutes long. So hopefully it will be okay. And then we'll move on to Jenny's presentation.
My name's Danny and I'm a member of Keyring and part of the Working for Justice group.
My name's Graham. I'm also a member of Keyring and a member of the Working for Justice group too. I'm
54 years of age and I've spent 22 years and 9 months in prison. And I've been in the criminal justice system for over 40 years.
My first time in prison was actually the same as Danny's. I was down for non-payment of fine. But of course it wasn't told me properly, or I couldn't understand properly about payments of fines through the court and probation service. They didn't explain to me in inverted commas, layman's terms or an easy read for them, should I say how to go about that. And I didn't even know that I was going to prison for non-payment of fine. I didn't think that was a prisonable offence. Nobody told me that. I didn't know I had a learning disability when I was going through most of the criminal justice system. I know there was something slightly wrong with me, if you like, but I didn't know what it was. When I got into the induction or whatever, the next thing was asking, do you want to have a cell on your own? I said no. So they thought, right, they'll put me with three other prisoners in the same cell. And unfortunately, for the next couple of weeks, I was constantly harassed, bullied, sexual advances. And because I wouldn't take him, I was put on a chair, just like this one, tied up, and half of my hair shaved off.
In the times that I was in the prison, as the old saying is, you learn by your mistakes. That's how you learn the rules. If you broke one and you got punished, then you don't have to do it again, because the rules aren't explained to you. You're given a pack when you go into prison. These are the rules. This is what you'll abide by. But especially with me, because I've got I can't read or write. So to go and ask somebody, would you read this to me? All she got was, we're not secretaries. Courts don't explain things right, and with people with learning difficulties, there's definitely no help there in courts, and I've been in quite a few of them.
Well, thank you very much indeed for inviting me to come and speak today at this Diversity Festival. I'm delighted to be able to be here and to tell you a little bit about the work that we've been doing at the Prison Reform Trust. The short DVD that you've just seen, the two gentlemen involved both have learning disabilities. Both, as you'd seen, have been through the criminal justice system, including in prison. Keyring, they're both members of Keyring, which is a supported living organisation, so it helps people with learning disabilities to live independently in the community. And the Working for Justice group that they're both members of was a group of people with learning disabilities who'd been in touch with the criminal justice system as suspects, defendants and offenders, who helped very much with the No One Knows programme, which I'm going to talk about. Now, I'm used to mostly talking to criminal justice audiences and people in healthcare who work with offenders in the criminal justice system. And I'm always very conscious of the number of sort of shorthands and acronyms and what have you that it's easy to slip into using. So if I'm not making myself clear at any point, please just wave at me and I will pause and explain more fully. Now, I think this is... yes. Okay. So this is what I'm going to cover. A little bit about the Prison Reform Trust, some facts and figures, adults with learning disabilities and difficulties who offend, which is the No One Knows programme. Then I will pause at that point for questions, if there are any, before moving on to talk about children with impairments and difficulties who offend, and then thoughts on the future of equality and diversity for people with learning disabilities and difficulties who offend. So about Prison Reform Trust, we're a small organisation. Our aim is to create a just and humane and effective penal system. We do this through applied research and we use the findings to develop recommendations and to influence change. We are tenacious. We knock on doors, we visit politicians time and time again. Sometimes they listen and things change, and other times they don't. Progress is always slow, but we do get there. And I have to say that a lot of people care, but it is a tremendously difficult and complex and unpopular area to work in. Douglas Hurd has been our president for some time, and we've got a new chair, Lord Wolfe of Barnes. Before I go any further, I want to run through a few facts and figures about offenders, prisons and life in prison. Some of you will have visited prisons and you'll be familiar with the criminal justice system and what goes on in prisons, but others won't. And I think it's an important context for the remainder of my presentation. So, the prison population currently stands at around 85,000, of which just over 4,000 are women. When Ken Clarke was last responsible for prisons, in 1992-93, the average prison population was 42,628, so it's gone up pretty remarkably. In the last decade, the women's prison population has gone up by 33%. In June 2009, just under 27% of the prison population was from a black or minority ethnic group, which compares to around 1 in 11 of the general population. The prison system as a whole has been overcrowded every year since 1994. Before being sent to prison, 15% of men and 19% of women didn't have any permanent accommodation. They weren't necessarily homeless, but where they lived wasn't permanent. And fewer than half were registered with a GP. 48% of prisoners are at or below the reading level expected of an 11-year-old. And 82% are at or below the level expected of an 11-year-old in writing. The number of sentenced prisoners aged 60 and over rose by 119% between 1999 and 2009. Over a quarter of newly sentenced prisoners report long-standing physical disorder or disability. 72% of men and 70% of women sentenced prisoners suffer from 2 or more mental health disorders. In 2009, more than a third of women prisoners self-harmed and 7% of men. There were 60 apparent self-inflicted deaths in custody, which is down from 92 in 2007. Over half of women in prison report having suffered domestic violence, and 1 in 3 has experienced sexual abuse before coming to prison. Of all the women sent to prison, 30% say they've attempted suicide at some point in their lives. So thinking about what goes on in prison, there are around 24,000 workplaces for prisoners across the prison estate. Most entail low-grade menial work. At best, under a third of the prison population is engaged in work activities at any given time. Around a third of the prison population is attending education classes at any one time. Prison has got a pretty poor record for reducing offending. 49% of adults are reconvicted within 1 year of being released, and for those serving sentences of less than a year, this increases to 61%. Prisoners who have problems with both employment and accommodation on release from prison have a reoffending rate of 74% during the year after custody, compared to 43% for those with no problems. So clearly, if you go into a home and you've got a job, it's a lot more effective when you leave prison. Community sentences are more effective by 7 percentage points at reducing reoffending rates than custodial sentences of less than 12 months. The age of criminal responsibility in England and Wales is 10 years, compared to a European norm of 14 years. The UN Committee on the Rights of the Child has said that an age of criminal responsibility below 12 is not acceptable. In September 2010, there were 2,070 children in custody, which is a decrease from the previous year. The number of children in custody is declining steadily, but we still lock up an awful lot of children. In 2009, just over 4,000 children aged between 15 and 17 years entered prison under sentence. That doesn't include those who entered on remand. 71% of children in custody have been involved with or in the care of social services before entering custody. 25% of young men in young offender institutions are or are shortly to become fathers. 76% of children in custody had an absent father and 33% an absent mother in the period before they were sent into custody. 39% had been on the Child Protection Register or had experienced neglect or abuse, and 1 in 8 had experienced the death of a parent or sibling. 90% of boys and 75% of girls in custody have at some point been excluded from school. 40% of boys and 53% of girls said they were under 14 when they last attended school. The rates of mental health problems for children in the criminal justice system are 3 times as high as for children in the general population. In 2008, there were 686 recorded incidents of self-harm by girls in custody and 743 by boys. 11% of children in custody have attempted suicide. Since 1990, 29 children have died in custody, most by self-inflicted death, and 1 following the use of restraint by prison staff. 74% of children released from custody in 2008 went on to reoffend within a year. So the offender population, especially children who offend, experience very high levels of often multiple disadvantage and have significant support needs. Many of those support needs are not met before they come into prison, and they remain unmet during their contact with the criminal justice system. So, moving on. Adults with learning disabilities and difficulties. No One Knows was a 3-year programme that examined the experiences of people with learning disabilities and difficulties in the criminal justice system, and it's about this particular programme that I'm going to talk about for the next part of my presentation. I want first to say a few words about learning disabilities and difficulties and which people we wanted to include in the research by describing them in these terms. Definitions used for research purposes with offenders vary enormously, and they include strict medical model definitions based on IQ, as well as wider social definitions that include a range of impairments and other difficulties. The World Health Organization defines learning disability as a reduced level of intellectual functioning resulting in diminished ability to adapt to the daily demands of the normal social environment. IQ levels are given as a guide, and the range 50 to 69 is indicative of mild learning disabilities, and it's people with mild learning disabilities that we see most often in the criminal justice system, mild to moderate, mild to borderline. Variations on the World Health Organization definition are followed in the 4 UK administrations, England, Wales, Scotland and Northern Ireland. Northern Ireland, all of which stipulate that an IQ below 70 is not of itself sufficient to diagnose learning disability, and that impairments of social functioning and communication skills should also be present. However, many people with an IQ of 70 and above will also experience major difficulties with understanding, with communication. And these may include, for example, people with borderline learning disabilities, people with speech and language difficulties, people with attention deficit hyperactive disorders, people with dyslexia, and people on the autistic spectrum, including Asperger's syndrome. We also took account of the Disability Discrimination Act, pre the Equalities Act. So for the purpose of the Disability Discrimination Act, whether a person is disabled is generally determined by reference to the effect that a particular impairment has on an individual's ability to carry out normal day-to-day activities. Now, while it's clearly not possible for the Disability Discrimination Act to list every impairment that qualifies, the examples that they gave included dyslexia, autistic spectrum disorder, and learning disabilities and difficulties. The bottom line in deciding who we wanted to include was those people who were most likely to be made vulnerable by the criminal justice system, rather than because they'd been given a particular label that defined their disability or their difficulty. We therefore didn't adopt any precise definition of learning disability and learning difficulty that would serve to either include or exclude people by a very fine margin. And we got into an awful lot of trouble around that, particularly from clinicians. However, I still believe it was the right decision to make. And actually, that decision did influence Lord Bradley in his report, and I'll come on to that later on. Having said that, there are occasions when precise definitions and diagnoses are really important, particularly for people with learning disabilities, because you often need that diagnosis in order to invoke relevant legislation, policy frameworks, safeguarding protections, and access to service provision. So whilst we were very fluffy on the one end, we were very crisp and clear on the other end. People with learning disabilities and learning difficulties are not a homogenous group. They're all individuals with a wide range of different life experiences, strengths, weaknesses, and support needs. However, many will share common characteristics which might make them especially vulnerable as they enter and travel through the criminal justice system. Now, what often makes things even more confusing is that the terms learning disability, meaning intellectual disability, and learning difficulty are often used interchangeably. I won't. If I say learning disability, I mean just that, and if I say learning difficulty, I mean learning difficulty. During the 3-year programme, we undertook a range of research, the third bullet point, and benefited from 2 advisory groups, and Danny and Graham, who you saw earlier, were on one of the advisory groups. These are the publications from the research, some of which are here today, and they're all downloaded, can be downloaded from the Prison Reform Trust website. After the presentation, if you want to come and help yourselves, it saves me carrying them all the way back to London. So, how many people are we talking about? To a large extent, that depends on what is being measured, what screening tool is being used, at what point in the criminal justice process the screening is undertaken, and by whom. Because some of the research screening was undertaken by people who were learning to use the screening tool at the time as they were doing the research, and clearly that skews results somewhat. A literature review that we did showed that 20 to 30% of offenders have got learning disabilities or difficulties that interfere with their ability to cope within the criminal justice system to a larger or lesser extent. Research by Pat Mottram found that 7% of prisoners have an IQ of less than 70, and a further 25% have an IQ between 70 and 79. And it's now generally acknowledged by, importantly, the Department of Health and the Ministry of Justice that between 5 and 10% of the offender population have learning disabilities. More prevalent studies. ASD, in the third bullet, autistic spectrum disorder. The Department of Health is less concerned about people with learning difficulties, more concerned about people with learning disabilities, but there are significant implications when it comes to the criminal justice system for both groups. So that 20 to 30% is particularly important for the criminal justice system. One final thing to say about prevalence. Some extremely powerful research. One of the most prevalent vulnerable groups amongst offenders comprises those who do not have an intellectual disability as formally defined, so that is the group of people with learning disabilities, but do have much lower cognitive and adaptive abilities than do either the general population or indeed the rest of the offending population. As part of the research, we interviewed prisoners with learning disabilities and difficulties. And in addition to the interview, we asked prisoners to complete a learning disability screening tool, a scale to indicate levels of depression, and another scale to indicate levels of anxiety. And I'm going to use quotes from these interviews to illustrate prisoners' experiences of the criminal justice system. I've purposefully selected quotes that highlight where things go wrong to demonstrate what needs to change and why. And whilst throughout the 3-year research programme, we did come across examples of good practice, which in the main, it has to be said, were down to the particular efforts and kindness of individual staff, rather than any routine systems. The overall picture was grim. So I don't feel I'm misrepresenting the research at all by simply showing you the downside. So the start of the journey at the police station. There are various safeguards in criminal justice and policing policy aimed at protecting the general welfare of vulnerable suspects, such as facilitating their access to treatment and support and reducing risks of miscarriages of justice that could arise from their vulnerability. Safeguards to protect vulnerable suspects generally apply only to people with learning disabilities because they're framed in language of mental disorder, and that wouldn't include, in the main, people with learning difficulties. However, recognising that a suspect has learning disabilities or is otherwise vulnerable, mental health problems, for example, is not straightforward. Certainly people with learning disabilities often try to hide their difficulties for fear of ridicule, to appear the same as everyone else, or to avoid embarrassment. You might have noticed on the clip earlier, Danny was about to say that he had learning disabilities but changed it to he couldn't read and write very well. Consequently, in the absence of any routine screening at the point of arrest or at any other point in the criminal justice system, an individual's support needs will often go unidentified and unmet. Many empirical studies strongly suggest that suspects and defendants with learning disabilities are vulnerable in the sense that compared to their non-disabled peers, by the way, I would say that that was the case with a lot of people with learning difficulties as well, but this research was particularly about learning disabilities. So are vulnerable in the sense that compared to their non-disabled peers, they are less likely to understand information about caution and legal rights, more likely to make decisions which would not protect their rights, more likely to be acquiescent and more likely to be suggestible. If the police believe a suspect is mentally disordered or otherwise mentally vulnerable, they're obliged under Code C of the Police and Criminal Evidence Act to call for an appropriate adult. Amongst other things, the appropriate adult should be present during police interview to support, advise and assist with communication and ensure that the suspect understands his or her rights. Less than a third of the people interviewed as part of the No One Knows programme received support from an appropriate adult. And this reflects research that shows an under-identification of vulnerable suspects by the police. While the police are obliged to call for an appropriate adult, there is no statutory requirement for provision. Now that sounds crazy, so let me just explain. Somebody with learning disabilities is at a police station. The police think there's something not quite right here. I think this individual is vulnerable. I will call for an appropriate adult. There is no statutory requirement for anybody to provide appropriate adult services. So that police custody sergeant might have a really well-organised appropriate adult scheme run by a local voluntary group or by local social services, and he can call on them and somebody comes along immediately to help. Or they may not have any scheme at all. Or it may be a scheme which is pretty, it's okay, but it's not great. And so the police and the individual suspect are sat twiddling their thumbs until an appropriate adult comes along. Some appropriate adults are well supported and receive training, but this is not always the case. One interviewer, E, told us how a taxi driver who happened to be at the police station at the time was his appropriate adult. Now, how appropriate is that? This contrasts with the provision of intermediaries for vulnerable witnesses and victims. Suspects are excluded from this provision. Intermediaries are often qualified speech and language therapists, and their availability is organised via the National Police Improvement Agency. Now, how that will work in the future, I don't know, because the NPIA is one of the bodies that is being disbanded. So quite what will happen after that, I don't know. But the point is that support's available automatically for victims and witnesses who have got support needs are not available to suspects and defendants. The right to legal advice is especially important for vulnerable suspects, not least because of the extra time and help that they're likely to need in understanding the legal process, and in particular in not making any self-incriminating statements or confessions. Arguably, the protection of vulnerable suspects could be enhanced if the duty to call for an appropriate adult was supplemented also by the duty to call for legal advice. Whilst I was waiting to come in for this lecture, I was reading some transcripts of interviews with young people, and the number who, and they had learning disabilities or learning difficulties, mental health problems, the number who said, I was going to tell the truth so I didn't need any help from a solicitor, was extraordinary. Whether you're going to tell the truth or not, you need support from a solicitor, you need legal advice. Information about a suspect's support needs where it exists will not necessarily be made available to the court. So, for example, if the police decide that somebody needs an appropriate adult, that information won't automatically be transferred to the magistrates in whose court the individual will be tried. Excuse me. There's a general recognition in law that defendants must be able to understand and participate effectively in criminal proceedings of which they're a part. This is reflected in the right to a fair trial enshrined in Article 6 of the European Convention of Human Rights and the case law that supports it. The requirement for effective participation is reflected also in the criteria used to determine fitness to plead, namely that the defendant can plead with understanding, can follow proceedings, knows that a juror can be challenged, can question the evidence and can instruct counsel. There's a scope for a variety of measures to be put in place to support vulnerable defendants in the courtroom to maximise their chances of participating effectively in proceedings. So, for example, under the Youth Justice and Criminal Evidence Act, certain special measures that were originally designed to support vulnerable victims and witnesses, but not vulnerable defendants, have been extended now to include vulnerable defendants. Further, in 2007, the Lord Chief Justice issued a practice direction to assist a vulnerable defendant to understand and participate in proceedings. It's only a practice direction, not in law. It's a practice direction. And last year, the Coroners and Justice Act extended the right to support from an intermediary to vulnerable defendants. And we all said, great, absolutely wonderful, but there's no implementation date. It would, of course, be so much more straightforward and fair if there was parity in the provision of support for vulnerable victims, vulnerable witnesses, and vulnerable defendants. Over a fifth of the people interviewed as part of the No One Knows programme said they didn't understand what was going on in court or what was happening to them. And over a third said that the use of simpler language and having things explained to them during proceedings would have helped. A small but significant number of people interviewed said they didn't understand why they were in court or what they'd done wrong, and similar numbers said they didn't understand that their sentence meant that they were being sent to prison. I've never been able to get to the bottom of this one. Who is ultimately responsible and accountable for ensuring a defendant's effective participation in court proceedings? Is it the court services, the magistrate or the judge in whose court the trial is taking place, the defence team? What role does Crown prosecution play? and we're still sort of puzzling that one. A 2008 report by the Joint Committee of Human Rights highlighted concerns about the rights of people with learning disabilities to a fair hearing as protected by the common law and Article 6 of the European Convention of Human Rights. The report went on to say that the evidence received by the Joint Committee, and I quote, suggests that there are serious failings in the criminal justice system which gives rise to discriminatory treatment of people with learning disabilities. So, moving into prison and where to start, I can only skim the surface. The detailed report is here. It appeared from the No One Knows research that prisoners with learning disabilities and difficulties were frequently left to sink or swim, generally relying on the goodwill of prison staff and other prisoners for support. Prison staff, officers in particular, could make all the difference between whether life was bearable for prisoners, even productive or not. Interviews showed that prisoners with learning disabilities were less likely than their peers to be in touch with family and friends, couldn't read and write very well, some of them didn't know how to use the phone, to know when their parole or release date was, didn't know when they could go home, to ask somebody if they didn't understand what was going on, to know what to do if they felt unwell, or to have participated in cognitive behaviour treatment programmes, which might mean longer in prison as a result, and I'll come on to that later. They were also the most likely to spend time on their own with little to do, and interestingly, the most likely to have some really positive ideas about the kinds of support that would help them whilst they were in prison. Prisons are largely paper-based regimes, meaning that information for prisoners is generally made available in writing. And to get things done, including routine things like ordering meals, getting your clothes washed, and arranging for visits from family and friends. In order to do all of those things, you've got to fill in a form. Now, if we think about how many people in prison can't read or write very well, let alone the numbers with learning disabilities and learning difficulties, it makes life pretty tricky, not just for prisoners, but for the prison staff as well, who are constantly being asked to help with things that if they were done slightly differently, they wouldn't. Prisoners with learning disabilities and difficulties were 5 times as likely as those without such impairments to have been subject to control and restraint techniques. So what happens when people get distressed, upset, angry, kick off, manhandled, often for good, safety, security reasons. So there were more than 5 times to have been subject to those techniques as people without those impairments, and they were more than 3 times as likely to have spent time in segregation on their own. Further, prisoners with learning disabilities and difficulties were almost 3 times as likely as prisoners without such impairments to have clinically significant depression. I'm not talking about just being a bit down, clinically significant depression and clinically significant anxiety, and many experienced both. Over the 3-year research period, a number of overarching themes emerged, and these are 5, which I'm going to run through very briefly. The research ended in 2008, and I'm really pleased to say that some progress, not a lot, but some progress has, but more importantly, continues to be made. In 2008, Lord Bradley was asked to undertake a review of people with mental health problems or learning disabilities in the criminal justice system, and his report was published in 2009. It made a number of recommendations, and these have really helped to drive forward change. If a report comes from Lord Bradley, it carries a lot of weight, and that has helped us enormously. And if you haven't read the report, I would commend it to you. So the overarching themes in a bit more detail. First bullet point, as I've already said, there's no routine screening to identify people who might have learning disabilities at any point in the criminal justice system. Subsequently, support needs are often not recognised, let alone met. The use of a screening tool has been piloted in 4 prisons, very successfully. But over a year, and we didn't do it, the Department of Health did it, almost a year later, we're still waiting to hear when it will be rolled out across the prison estate. And many prisons want it. People ask regularly, but for some reason we're still waiting. The government has committed to all police stations and courts having access to criminal justice and liaison and diversion schemes by 2014. These schemes are really important, not least because they will assist in identifying people with learning disabilities at the point of arrest, and appropriate interventions can be made. Now, I'm not just talking here about diverting people away from the criminal justice system, which is one option, but it's also very appropriate for people to travel through the criminal justice system sometimes, but they do need support. And the liaison and diversion schemes will be able to help identify what the difficulties are, what support would help, and what the most appropriate outcome would be. Information sharing. There are huge problems with information sharing between different parts of the criminal justice system. Example, between police and courts if an appropriate adult is called, and then between criminal justice and healthcare. Information is frequently lost. When we did research, people told us we always send information, and then they said but we never receive it, so it gets lost somewhere. But there are also a lot of misplaced concerns about confidentiality, which often restricts the sharing of important information. And I'm not saying you should share information willy-nilly, but there are frameworks that can be put into place that will enable the timely and effective sharing of important information. Second bullet point, research with prison staff showed that almost 2/3 were concerned about the quality of service provision for prisoners with learning disabilities and difficulties, and more than 3/4 said there were gaps in service provision. Inappropriate interventions. Interventions are programmes and activities that offenders are required to undertake as part of their sentence. However, they are not always accessible for people with learning disabilities or learning difficulties. For example, the vast majority of offending behaviour programmes are inaccessible for people with an IQ less than 80. Put to one side the ability to read and write and take part in group discussions, they're not accessible for people with an IQ below 80. Now, if you remember right at the beginning, a prevalence study found that 25% of prisoners had an IQ between 70 and 79. That excludes quite a lot of people. Anne Owers, the previous Chief Inspector of Prisons, described this predicament as Kafkaesque. And what she meant was people being unable to access the very programmes they needed to complete in order to be released from prison. Now, this has very serious implications for prisoners, and for some it will mean longer in prison as a result, as happened to Mr. Gill, the bracket at the end. Gill versus the Secretary of State for Justice is a recent case whereby Mr. Gill, a prisoner with learning disabilities, took Jack Straw to court and won, because he couldn't access the offending behaviour programmes he needed to complete before he could be released. At the time of the judgment, Mr. Gill was well over twice his tariff, meaning that he had spent twice as long as in prison as he could have done had he successfully completed the required offending behaviour programme. Yes?
So, was Mr. Gill on an IPP sentence?
Pass. I don't know, but if you leave me contact details, I can send you the case. I mean, if you Google the case, you'll find it. But I'm not sure. I was more concerned about his learning disability than IPP. Yeah, but he may well have been. We certainly interviewed, and in here, there is a tragic quote from a young man who was on an IPP, and he was saying, you know, this is just, I find it hard enough to cope with the sentence, let alone the fact that I've got to learn to read and write before I can do the, you know, he'd been trying to learn to read and write all his life. So, a big problem. First bullet point, some progress in learning disability awareness training has been made, especially within the prison service, thanks to the Department of Health. Progress has been slower in probation, the courts and the police, but what we came across all the time were pockets of really excellent practice. And certainly I know there's some really good stuff that goes on in local police areas when it comes to awareness training and support for staff in working with vulnerable suspects. So across the board, it's not good, but there are pockets of shining practice. Second bullet, in research undertaken by us with prison staff, prison officers spoke an awful lot about not having enough leadership, with many saying that what would really help was more guidance and support from the senior management team, or really just an indication from the senior management team that they recognised that this was a problem for staff. And Lord Bradley's report has really helped in this regard, because he can bring matters to the attention of senior managers, policymakers and politicians in the way that we find it more difficult. But it's only with real commitment at a senior level, coupled with the need for collaborative working, that structural and systemic change will occur. Working effectively to prevent offending and reoffending, particularly of people with learning disabilities and learning difficulties, isn't a job for criminal justice agencies alone. Other government departments and local services, particularly people like housing, learning disability partnership boards, education and so on, need to be involved as well. It's a real collaborative effort, and it's no good waiting for people to end up in the criminal justice system. We really need to do some of that preventative work beforehand. Evidence from the No One Knows programme demonstrates that people with learning disabilities and learning difficulties are discriminated against personally, systemically and routinely as they enter and travel through the criminal justice system. Those responsible for criminal justice services are failing in their duty to promote equality of opportunity and to eliminate discrimination. Far too many instances of disability discrimination and possible human rights abuses have emerged, and these are four of particular concern. Maltreatment of people with learning disabilities and learning difficulties by police and by prison officers. The lack of an appropriate adult for vulnerable suspects during police interview. Defendants with learning disabilities and learning difficulties being unaware of what is happening to them during their trial and an inability to understand decisions of the court. And prison information and regimes that are inaccessible to prisoners with learning disabilities and difficulties. Right, I'm just going to pause there for a moment. Don't all rush off because I haven't finished yet. But before I move on to children who offend, I thought it might be a good point to just pause and ask if there are any questions at this stage.
Is it okay to wait for the microphone until you ask the question, just so people behind can hear and the video as well?
Thanks. I just wondered, what your research found in terms of looking at the prospects of movement from the prison to hospital beds, and what kind of barriers and what kind of constraints were found in that kind of aspect of the work.
Okay. We didn't look at that particularly because that tends to be much more where people who are very mentally ill, it would apply to them much more than it would to people because of their learning disability. I'll come on to a quote where a young man was transferred because his learning disability was such that he should never have got to prison. But in the main, we're talking about people with mild learning disabilities who, with support, can cope with prison. I mean, I've got real issues with whether they should go to prison or not. I mean, I just don't think they should. I think they should go through the criminal justice system because I think that is appropriate in many instances. But prison, as it is set up today, is so inappropriate, it is damaging. So I can't really answer that wisely. I do know that there are huge difficulties with transferring people out. And it's, there are blockages all the way, and it's often to do with funding and who pays. But sorry, I can't offer any more than that, I'm afraid. I can get further answers on the mental health side if you're interested, and I'd be happy to do that.
Hi. How do you as an organisation define the terms rehabilitation and reintegration?
Oh, God. Right, okay. How do we define the terms? I'm not sure we do define the terms. What we believe is that that prison should be used as a last resort. Prison is appropriate for certain prisoners who are violent, who are extreme in their violent behaviour. What we do believe passionately is that if you send somebody to prison, then you need to do something with them while they're there, so that they are less likely to offend and more likely to lead productive and useful lives on release. What is perfectly clear is that prison, on the whole, fails to do that. We are delighted at the moment with the Green Paper. We applaud Ken Clarke's commitment to reducing the prison population for reasons very different to why we would want it reduced, but nevertheless, reduce is what we're... And we think that the idea of prisoners being able to work full-time weeks, a full-time week, is extremely good. So in terms of rehabilitation, I think you need to look at offending behaviour. I think you need to look at and meet the massive support needs that people have. I think you need to encourage, support, educate, train so that people are able to come out and be equipped with the skills that they need to find work. And I think on release, people need support to get back into society so that they don't come back again. Now, I suspect I've not really answered your question, but that's as far as it gets at the moment.
Do you therefore think that rehabilitation and reintegration are interchangeable terms?
Possibly.
Thank you.
Happy to talk after.
We know that generally offenders can be touched with about 19 offences before they actually get into the prison system. Is there any evidence to say people with learning disabilities are in that system much faster with having committed less offences?
No, there isn't, and that is largely because we don't count who we don't know enough about who the individuals are in order to do that research. Because in order to do that research adequately, we would need to know who has a learning disability, and we don't. Does that make sense?
It does, except
yeah.
You've come up with a high percentage of learning disabilities within prisons. So
yeah.
If that's not been measured, how do we get those figures?
That's been measured by research. It hasn't been measured, so we're not able to count 1, 2, 3 you have. Let's look at your record. 4, 5, 6 you haven't, so we can compare it with that. That's what we haven't got.
Quite general.
Yeah.
Thank you.
Okay, should I move on? Having failed miserably with most of the questions, we'll leave them, and I'll move on to the next bit. Right. Okay. I'm now going to turn my attention to children, i.e. those aged between 10 and 17 years. The Prison Reform Trust has a 5-year programme with the aim of reducing child and youth imprisonment, and within that, my role is to focus on those children with particular impairments and difficulties, such as learning disabilities, learning difficulties, mental health problems and communication difficulties. All children in the criminal justice system are presumed vulnerable by nature of their young age and developmental immaturity. Many, we would argue, are doubly vulnerable. That is, they're disadvantaged also because they experience a range of impairments and emotional difficulties. So, how many children with learning disabilities and difficulties are there in the criminal justice system? Research, so it's research generally, coming back to your point, shows that almost a quarter have very low IQs of less than 70, and a further third have an IQ of between 70 and 79. Almost 3/5 in total, or in other words, the majority. Now, whilst this isn't the same as saying that most children who offend have got learning disabilities or borderline learning disabilities, remember the definition earlier on, it is strongly indicative that he or she will experience difficulties in communication, difficulties in expressing themselves and in understanding ordinary social cues, difficulties with learning and or disrupted learning experiences, both of which might lead them to function at a significantly lower level than the majority of their peers, and some of those may of course have learning disabilities or be on the autistic spectrum. Research further shows that around a quarter have special educational needs and almost half are underachieving at school. 2/5 have mental health problems, 3/5 have communication difficulties, and at least 15% have ADHD. I say at least because it's a very small piece of research, and when you ask youth justice staff, they reckon it's much higher, but because we don't screen, we don't really know. There are similar difficulties with identifying children's impairments and difficulties as there are for adults. However, some really good work is beginning to take place. For example, the Centre for Mental Health, formerly the Sainsbury's Centre for Mental Health, has got some good pilots for liaison and diversion, and triage by youth offending team staff. If I say yacht, I mean youth offending team. Youth offending team staff at the police station. So they are there to identify children with support needs as quickly as possible, and where appropriate, move them out of the youth justice system. There are also particular supports for children, for example, the use of intermediaries, appropriate secure accommodation for children at the police station, and the provision of appropriate adults who must be present during police interview. And for children, the appropriate adult service is statutory and is mostly provided by youth offending teams. However, through a slip of the pen, 17-year-olds are not included in that provision. So although they are children, they may or may not receive support. Look at PACE. It only goes up to but doesn't include 17-year-olds. Again, I'm going to use quotes to illustrate children's experiences of the criminal justice system. And these are their experiences in court. These quotes are from 18 to 21-year-old prisoners, and they were responding to the question, what was court like for you? I've included them because although we didn't ask how old they were when they were in court, it's probable that they were under 18 years old at the time. There are, of course, really serious implications in not meeting children's support needs, and the first two bullet points here relate to children with learning disabilities. The first one, case of SC versus UK, in which the European Court of Human Rights ruled that the right to fair trial of the applicant, who was an 11-year-old boy, had been breached because his young age and significant learning difficulties meant that he had had insufficient understanding of the proceedings and their potential consequences. The court therefore judged him not to have had effective participation in the trial. In the later case, the second bullet point, the administrative court ruled that neither youth nor limited intellectual capacity on the part of the defendant necessarily leads to a breach of the right to a fair trial, but that the court hearing the case should adapt its procedures to ensure the defendant can actively participate in the proceedings, which I think is only right and fair. Going through a process because of your particular behaviour can sometimes be extremely useful, but you need support to be able to participate effectively. And I've already referred to the second and third bullet points, which apply equally to children as they do adults. The next two quotes I've included because I think they speak volumes, and this one is from the head of a healthcare in a young offender institution, and is again concerned about the appearance of children in court. So on speaking with a young person who had just come into the establishment, he told me he couldn't understand why he'd come to prison. When he asked me, miss, if I was remorseful, I said no, and then he told me I was coming here. This young man hadn't heard that word before. He also said he didn't have much idea of what was going on in court and didn't understand what people were saying, although he knew they were talking about him. This, I think, is one of the most tragic quotes I've come across. The young man in question had slipped through a number of safety nets, ending up in prison before going on to receive appropriate care and treatment. And this is one of the diversion out of custody into more appropriate health care. But you don't see it often, it has to be said, for people with learning disabilities. It's much more associated with people who are very, very seriously mentally ill. Over the last 10 years or so, there's been really good progress made in youth courts, and these are just some of the legislative changes and guidance that have been made. Appropriate support will, however, can only be put in place if a child's particular impairments or difficulties are known about, which presents us with a real dilemma. There is no systematic or routine procedure for identifying possible learning disabilities or communication difficulties at any stage in the youth justice system. We are better at, but not good, at identifying children with mental health problems and certain learning difficulties. ASSET. ASSET is a youth justice assessment tool used by youth justice staff to assess children when they first come into contact with the youth justice system. And while ASSET provides a lot of useful data, it does not screen for learning disabilities or communication difficulties. And the two quotes there are from the government. Healthy Children, Safer Communities is the publication it comes from. Categorically doesn't screen for these impairments. So, with this in mind, we wondered just how youth justice staff did identify and support children with particular impairments and difficulties, and together with the Association of Yacht Managers did some research that involved over half of youth offending teams in England and Wales. And what we wanted to find out was how children with a range of different impairments and difficulties who offend are identified and supported by youth justice staff, what training and support is available to help youth justice staff, and what would most help youth justice staff. We inquired about a number of different impairments and difficulties, and I'm going to focus on just two: learning disabilities and communication difficulties. We wondered how yacht staff found out about possible impairments, and these are two of the things we asked about. We explored what screening tools were used, and also about the quality and timeliness of information received from children's services was like. Now, bearing in mind youth justice services are part of children's services, so you would hope that there would be a free and useful flow of information. Somewhat surprisingly, only around half of yacht staff routinely asked for information from children's services. And when you looked at what happened when they did ask, you could understand why only half bothered in the first place. While around 2/5 said they did use screening or assessment tools for learning disabilities and communication difficulties, I have some doubts as to the validity of the tools that some people said they used. For example, a number of staff said they relied on ASSET, and these are some direct quotes. But as I've already shown, this isn't what ASSET does. So people were using a form thinking that it screened and would identify children with learning disabilities, when actually that isn't the purpose of the assessment in the first place, which actually produces worse results than if no screening was done in the first instance. We wanted to find staff views on the proportions of children with learning disabilities and communication difficulties at their yacht, and how closely this matched research findings. This is a view held by yacht staff, often not based on screening or assessment, just their particular opinion. Just over half said numbers were about the same, however many said that numbers at their yacht were lower. So what's going on? Now, it seems to me there are two possible scenarios. There are probably many more, but two particular ones. Research findings are wrong, or we're not very good at identifying when children have particular impairments and difficulties. And in the absence of any routine screening and data collection, I would propose that the latter is the most accurate position. Looking at this slide, I want you to bear in mind the high numbers of children with possible learning disabilities, borderline learning disabilities and communication difficulties in the youth justice system. The figures here show the best possible scenario because there were overlaps. For example, yachts that had a mental health worker with learning disability expertise may also have had access to learning disability CAMS, Child and Adolescent Mental Health Services. The most worrying data is that half of the staff who responded didn't even know if their yacht did have access to learning disability CAMS. The yes but on the third bullet point relates to long waiting times and children being ineligible for services due to age or because they had mild learning disabilities and therefore didn't pass the threshold test. What training and support did staff receive? Well, fewer than half said their yacht did disability awareness training, and of this group less than half said it included learning disabilities, and even fewer said communication difficulties were included. Slightly more than 2/5 received specific training to help them identify when a child might have particular support needs. And I'm not talking there about training that would help them to specifically identify and to diagnose, but just indications to look out for, things that might make them wonder if an additional assessment or diagnosis was necessary. Statistics, record keeping and the DDA, not a very exhilarating title, but my goodness me, we unearthed some quite interesting data on this one. So we asked, does your yacht have a member of staff with responsibility for disability? Now, to start with, only 138 out of the potential 208 people answered the question, and of that group, less than 1 in 10 said yes. Only 2 respondents said they knew what proportion of children at their yacht had a disability, and 1 of them said there were none. Now, although I wasn't expecting a great response when it came to the Disability Equality Scheme, I did expect rather more than 16 out of a potential 208 to respond in the positive. Yacht staff were asked if, in their opinion, children with learning disabilities or communication difficulties were more likely or less likely to receive a custodial sentence than children without such impairments, or whether they didn't really think there was any difference. And as you can see here, more than half said they were more likely to receive a custodial sentence, which was really rather shocking. So to shed a bit more light, we ran a number of focus groups with yacht staff to find out more. And from the groups that we held, some common themes emerged. According to the focus groups, the chances of children receiving a custodial sentence was affected by whether a child's impairments or difficulties were recognised and their support needs met, particularly during court proceedings. Now, a slight aside here, different piece of research, nothing to do with us, a survey of magistrates. 80% of magistrates surveyed said that the attitude and demeanour of a young person influences their sentencing decisions. So, a child with, for example, learning disabilities or communication difficulties, whose support needs have not been recognised or met, will be in for a pretty tough time of it when it comes to being sentenced. Conversely, if a child had been identified as having learning disabilities and support was put in place, there was a much more likely chance that the court would be more understanding and possibly more lenient, certainly more concerned about what the sentence might be. So other things that were identified by the focus group, the availability of appropriate youth justice programmes. Now, when we did this research, yacht staff spent an inordinate amount of time doing their level best to make programmes appropriate for people with particular difficulties. But if they weren't skilled or experienced or qualified to actually make those adaptations, the adaptations that they did make wouldn't necessarily help the individual child they were trying to support. And in many respects, bad help is worse than no help, because when the child fails, you think, well, we've done our best. We've helped as much as we can. So the availability of appropriate youth justice programmes, linked to which the chance that children with impairments or difficulties will fail to comply with those programmes, i.e. with their court order, and failure to comply is often punished by being returned to court and the likelihood of a custodial sentence. So that's what youth justice staff told us to underpin these findings. So overarching themes, well, not surprisingly, they're remarkably similar to those for adults. No routine screening or assessment and poor information sharing, inadequate support, and often, despite the best efforts of staff, inappropriate interventions, limited awareness, training and support for youth justice staff, underdeveloped collaborative working, and disability discrimination and possible human rights abuses. So, the future of equality and diversity and people who offend, which is what I was trying to address. And what is the future? Well, there is an awful lot going on at the moment, and these are just some of the consultations, decisions and legislation that will inevitably impact on the future of equality and diversity for people who offend, excuse me, for better or worse. And I really don't know what the impact might be. Certainly, the economic drivers at the moment couldn't be harsher. a 30% cut in Ministry of Justice staffing and resources, which might mean 10,000 fewer prison staff by 2014. And at the same time, the Justice Green Paper, which does offer room for consultation and practical penal reform. There are three things that give me particular hope. One is events like this, of which there are an increasing number. Crime is always high on the political agenda, whereas offenders are not. And what goes on in prison is a very closed world and generally isn't open to people who aren't directly involved in criminal justice. However, there's a growing concern, particularly about the high numbers of people in prison with mental health problems and who are otherwise vulnerable. For example, the increasing ageing population, more recently the number of people with learning disabilities in prison. And one example is the Women's Institute, which is currently running a nationwide campaign about the inappropriateness of prison for mentally ill offenders. And when they write to Ken Clarke, he responds, and they've got an event with him. The Bradley report is very important, I've said that already. And while it's not about equality and diversity per se, its recommendations, some of which are being vigorously pursued by the coalition government, will help to ensure that the rights of certain offenders are upheld and that the treatment that they receive is more appropriate to their needs. And as I've already said, the Green Paper does offer some real hope for reform. And thirdly, the criminal justice and healthcare staff who work with offenders on a daily basis, many of whom are highly committed and want to do what is right and what is best for the individuals in their charge. And theirs is no easy job. You know, sit for an evening in a busy custody suite, visit a prison, go and sit in a court. It's a jolly difficult job. So theirs is not an easy job, and they're so often picking up the pieces of lives damaged by a society that is not equal, that doesn't celebrate diversity, that fails to notice the vulnerable or to act to provide support for the least able in our society, and they wash up into criminal justice. So we can't rest easy. There's an awful lot to be done. And I very much appreciate the opportunity to have shared some of my thoughts here with you today. Thank you very much.
Does anyone have any questions for Jenny before we finish? We've got about 10 minutes.
Another difficult question from the young lady.
I'm sorry, you couldn't make me.
That's quite all right.
You refer a lot in your presentation to the use of IQ testing. What means of establishing IQ is used to gather these statistics, and how do you feel about the criticisms often levied as IQ testing as a means of establishing ability?
Depending on the research, depending on who is doing the research, different tests are used. And therein lies the difficulty. Pat Mottram used the HAZY. The pilot screening tool that was tested in prisons was the Learning Disability Screening Questionnaire. They don't simply test IQ, either of them. So it's not like the WACE, which is just an IQ test, and it would give you that particular response. IQ gives you certain information. It doesn't necessarily mean that you've got a learning disability. And as the World Health Organization definition and the definitions used by the 4 different administrations, they all look for more than just IQ. So I think IQ testing can give you certain information, but it's limited, and you need more than that. You need the social adaptability and how people are getting on in their environment, and you need conversations with carers and support workers to get a real picture. So I think it has its place, but I think it should be used in a limited way.
What happens if, say, just out of interest, if a child goes into a young offenders institution or whatever and is diagnosed to have, say, ADHD or something like that, but comes out at the other end of the IQ spectrum, comes out with an IQ of 150, say, what educational provisions, if any, are in place to help them?
That really depends on which young offender institution he or she is in. and how good that particular provision is. Education is the responsibility now, actually, of the local authorities for young people. And in some areas it's extremely good, and they've got special educational needs coordinators and highly trained and skilled staff. And in other areas it's not so good. So it's an ad hocery, and it depends what support is available as to how much that individual will be helped and supported. And exactly the same when they come to leave prison. Some support is very good and will pick up and work with, and others isn't. And a lot of this is about identifying what is good and looking at how we make that the not just best practice in pockets, but how we make that routinely and systemically available across the piece.
Like a template for the rest of the country. Almost.
Absolutely.
Thank
Yeah.
you.
Given the recent research from the Howard League and NAPO on the extent of British veterans in the prison system and the criminal justice system generally, has any of your research found British veterans who also fall into these vulnerable categories of having learning difficulties and learning disabilities?
No, because we didn't ask if that's where people were coming from. What I do know, though, is I think you're less likely to find them in the learning disability group. You may well find them with learning difficulties, but learning difficulties without lower IQ levels. I think that if you looked at the figures, they would be much more vulnerable because of mental health concerns and mental health problems that they have pre-coming in, and certainly the high level of former services personnel who are homeless would contribute towards that. But certainly in the work that we did, I think it would probably be quite a small, if any.
Thank you.
Okay, any more questions?
Hi, I know that the Howard League have been quite scathing and highly critical of the work of the Youth Justice Board in not disclosing things like their control and restraint manuals for young people and children. I just wondered what Prison Reform Trust's stance was towards kind of the Youth Justice Board being reabsorbed back into the Ministry of Justice.
I think there needs to be a body, a group, a department who are concerned particularly with youth justice, in the same way that I think there needs to be a body, a group, a department concerned about women in prison, and so on. I could go on. Whether they need to be a separate organisation like the Youth Justice Board, arm's length organisation, I should say, like the Youth Justice Board, I'm less sure. I think it is much more what they do, how effective they are in doing it, and what independent clout they have to say where things are wrong and need changing. So I think the function is hugely important, and certainly one of the things we will be doing is watching very closely how that function is absorbed, and will be paying particular attention to any loss of ability to influence positive change.